Hey y'all, we are the Stewarts. My husband, Russell, is an artist, and I am May, and I have an interest in true crime. We decided to merge our two interests together. Enjoy this calming visual while listening to a tragic story. This is Stew Art and Crime. December 4th, 2000. Some young men were breaking into cars on a Houston bayou when police officers came upon them and a chase ensued. The thieves took off in different directions and the police followed suit. The two Harris County deputy sheriffs were Barrett Hill and Warren Kelly, and the two thieves were Rob Will and Michael Rosario. Deputy Hill was able to get Rob Will in custody rather quickly, but Deputy Kelly unfortunately lost sight of Michael Rosario, and that is when gunshots were heard over the police radio. 30 minutes later, Deputy Hill was found dead, and Rob Will was nowhere to be seen. Will was caught with the murder weapon 70 miles away in a stolen vehicle, and he also had a gunshot wound on his left hand. Rob Will was arrested and charged with the capital murder of Deputy Barrett Hill. 38 years old, Deputy Hill served in Desert Storm with the National Guard. He had served as a jailer for the Harris County Sheriff's Department for the last 3.5 years and was currently doing field training under Warren Kelly to become a patrol deputy. At the time of his death, he and his wife Kathy had been married for almost 19 years, and they had 2 kids together, both girls. Rob Will was born in 1978 in Harris County, Texas. He had a difficult upbringing. He was physically and sexually abused throughout his childhood, and when he was 10 years old, his father, a heroin addict, was murdered. He dropped out of school in the 9th grade. At the age of 14, Rob Will met Michael Rosario. Rosario is the son of a Houston police officer, but he got into a lot of trouble throughout the years. So when these two came together, they did a lot of stupid things. The night Will decided to go along with Rosario, he was starting to get his life on track. He had already earned his GED and had enrolled at Houston Community College, studying child psychology and moving forward with a 3.4 GPA. He also had a 5-month-old son, so the thought of extra cash, even getting it illegally, was too appealing for him to pass up, not realizing that this decision would end with him being put on trial for murder and facing the death penalty. Before we get into the trial, let's first take a look at the relationship between Texas and the death penalty. Texas began its capital punishment in 1819 with hangings, and with some exceptions being made for the firing squad. Starting in 1924, however, the electric chair became the main method of choice. In 1972, a federal court decision shut down executions nationwide, but just 4 years later, in 1976, they returned. And since that time, Texas has had 567 executions, or about 40% of the total 1,512 men and women that have been executed in the country. There's a lot of information we are going to get into about this case, and since the names are similar, I will refer to the fallen officer as Deputy Hill, and Rob Will as Will to avoid confusion. The trial for the murder of Deputy Hill started in January 2002. The prosecution gathered testimony and evidence that they believed to be highly incriminating of the events leading up to Will's arrest. First, I will tell the detailed story of that tragic morning, and then go deeper into specific evidence and testimony from the trial. At around 6:30 a.m. on December 4th, 2000, the police received a report that 4 males were breaking into a vehicle at an apartment complex. Deputy Hill and his training officer, Deputy Warren Kelly, responded to the call. When the police officers pulled into the dark parking lot, they found 2 men standing outside. The men appeared to be removing parts from 2 vehicles. As Deputy Kelly pulled the police cruiser up to them, the men ran in different directions. The officers got out of the car and gave chase. Deputy Hill followed one of the men, later identified as Will, across the road into a field. Deputy Kelly called for backup as he pursued the other man, later identified as Michael Allen Rosario, in the opposite direction. The police officers' pursuit placed them out of each other's sight. A few moments later, Deputy Hill was shot several times and died. No one saw Will shoot Deputy Hill. Only inferences explained what happened in the short time between when Deputy Kelly saw Deputy Hill begin pursuit and when he eventually saw Will flee the area. Transmissions over the police radio, however, helped tell the story of how Deputy Hill was killed. Not long after giving chase, Deputy Hill announced over the radio, "I've got one in custody." A minute later, the suspect that Deputy Kelly had been chasing disappeared around a tree. Deputy Kelly radioed that he lost him on the bayou. 8 seconds later, gunshots sounded over the radio. The police radio then broadcasted gasping sounds and another burst of gunfire. After the shots, Deputy Kelly saw Will flee the scene. Will fled to a nearby apartment complex where Cassandra Simmons was sleeping in her parked vehicle. That is when Will opened her car door. He ordered her outside the car, and she screamed, as Will put a pistol to her neck. Will exclaimed that he had just shot a policeman. He stole her car and drove away. Let me interject here with some information from a Rolling Stones article. The woman whose car Will hijacked testified that he told her he had just shot a cop. On the day her car was stolen, however, she didn't mention that fact in any of the 8 conversations she had with officers, even though she knew a cop had been killed. She didn't remember it until the prosecutor was prepping her for the trial, 13 months later. About a half hour later, searchers found the body of Deputy Hill, approximately 470 feet from where Deputy Kelly had lost Rosario. The police conducted a thorough investigation of forensic evidence at the crime scene. The police recovered 7 spent shell casings and 2 projectile fragments from the area near the body. Deputy Hill's gun was in his holster, though it was not snapped shut. An investigator found Deputy Hill's handcuffs on the ground, but later, he could not remember whether they were in an opened or closed position. An autopsy revealed that Deputy Hill suffered gunshot wounds to the head, neck, chest, and wrist. Will's blood was found on Deputy Hill's shoe. Will was arrested 70 miles away with the murder weapon, a .40 caliber Sig Sauer pistol, and had a bullet wound on his left hand. The prosecution's closing argument summarized the crime. The physical evidence tells you everything that happened out there. As Deputy Hill goes to take Will into custody, the Sig Sauer comes out and the deputy is shot right here in the bulletproof vest. Don't you know, that morning Deputy Hill must have felt pretty safe. He's wearing his bulletproof vest. He's protected from the bad guy. And he's protected from the first shot. The first shot goes into his side and gets stopped in the bulletproof vest. And at that moment, there's a huge bruise created as the result of the humongous amount of impact that the bullet had as it was discharged from Will's weapon. At that point, from the dispatch tape, there's a pause. As Deputy Hill reels back and Will realizes that he's just shot himself in the hand. And at that point, Deputy Hill probably goes to reach for his radio and his arm comes up. We know that a shot goes through his wrist. It goes through his wrist and into his shirt. And at some point, he falls over. And at that point, Will had an opportunity to get away, but he doesn't take it. Will, based on the physical evidence out there, takes the opportunity to take his .40 caliber Sig Sauer that he's already shot several times and finishes the job. And he takes that gun and based on the evidence out there, as Deputy Hill lays on the ground, the shots are filed into his head, into his face. There's bullet fragments found near his head in the ground, inches under the dirt of the ground surrounding Deputy Hill's head. The shots, the final shots, are fatal. Those are the ones that kill Deputy Hill. The prosecution's case seemed to be based mostly on circumstantial evidence. The defense pointed out that Will had been searched and handcuffed prior to the murder. There was no forensic evidence supporting the charge. In fact, some items were inconsistent with charging Will, and other items were never tested. The GSR, gunshot residue, tests are completely inconsistent with Will acting as the shooter, and there were several witnesses that were available to testify that the co-defendant, Rosario, admitted to the murder, providing sworn affidavits, and one actually testified in court. Now it was the defense's turn to share their evidence and testimony that they believe point to Michael Rosario as the actual shooter that morning. They decided to focus on the few moments when Deputy Hill, Will, and Rosario were unobserved. This is the following exchange during the cross-examination of the dispatch records manager and Will's lawyer. Question: And you, through your training and experience, you would understand custody to mean that he was in control of that suspect, correct? Answer: Yes, sir, I would. Question: As a matter of fact, the dispatcher relays to the other units, recognizing that he has control of the person. Clear. One in custody at 6:36. At trial, Deputy Hill's partner agreed that he never made a positive identification of Rosario, and that he could have been chasing any one of these individuals. But if indeed he was chasing Rosario, the radio transcript and his own testimony at trial show that Rosario would have had between 26 seconds and 104 seconds, and not the 8 seconds prosecutors claim to reach the scene and shoot Deputy Hill. In addition, according to the K-9 unit report, the Harris County Bloodhound tracked Rosario's scent all the way back to the scene of the murder. The reporting detective noted that the Bloodhound wanted to track all the way to Deputy Hill's body, but was not allowed to enter the inner security perimeter. Next, we will hear the defense cross-examination of a senior forensic chemist from the Harris County Sheriff's Office. Question: But yet again, if there are 0 particles of antimony, a particle of GSR, present, under your standards or the Harris County standards, again, you're not going to tell us it's negative of antimony. You're going to say it's inconclusive, correct? Answer: Yes, sir. Question: So moving on to Mr. Will's test, his hands were inconclusive. In other words, you can't tell the jury today as you sit here reading this report that having examined my client's hands using an AA atomic absorption test, that his hands were positive for gunshot residue, correct? Answer: Correct. Will's left hand, which had a close gunshot wound, tested positive for GSR under the SEM. The following exchange is during direct examination of the expert witness by the Assistant District Attorney. Question: Suppose someone is actually shot, injured in an area around their hands. Do you expect to see any of these particular elements, gunshot residue, near or on their hands? Answer: If it is a close-range shot, absolutely. The chances of deposition are very significantly increased. Question: Okay, so if someone is shot in their wrist, and depending upon the angle of their hand, even if they had gloves on, these chemicals could enter into the upper palm of their hand? Answer: Yes, ma'am. Will's right hand had no traces of GSR. Rosario's hands were neither bagged nor tested for gunshot residue. The defense now tried to provide reasonable doubt by sharing evidence and testimony that pointed the finger at Michael Rosario. Rosario was subsequently arrested for capital murder, but was only charged with car theft. Both he and Will were housed at the Harris County Jail. On December 9th, 5 days after the murder, Rosario's parents brought investigators the clothes he supposedly wore on December 4th, carefully washed and folded in a neat pile. Rosario's pants were tested after his father handed them in to police. The pants were stained with blood, but forensic services were unable to extract any DNA, as the pants had been bleached, destroying all DNA and blood evidence. Forensic scientists also testified that Will's clothing had neither been cleaned nor bleached, which would have enabled the removal of DNA evidence prior to testing. The only DNA found to be present on Will's clothing were his own. Next, we will hear witness testimonies of those who saw Rosario that morning. Rosario initially ran to the apartment of a friend of his, but the friend's roommate refused to open the door. The roommate described him as crying and sweating at the door. Unable to gain access to his friend's apartment, he ran instead to Will's apartment. When there, he confessed to rob Will's girlfriend and the other occupants of the apartment that he just shot a police officer and accidentally shot Rob Will. Rosario proceeded to remove his bloody clothes and wash and pour bleach over them to destroy any DNA evidence. He took the holster and gun case and spare bullets of the murder weapon and placed them in an outside utility closet with a note that read, "Rob, here's my stuff." Rosario signed it with the name of a mutual friend of both his and Will's in an attempt to frame their mutual friend. Several people witnessed Rosario at the apartment, covered in blood and performing all of the above stated actions that day. As of today, all witnesses have provided sworn affidavits. Then the defense went on to dispute the claims that Will accidentally shot himself and then shot Deputy Hill. According to the prosecution's ballistic expert witness, the first shot was fired from a distance of less than 8 inches. If the first shot took off Will's knuckles, as they claim, and it was shot from less than 8 inches, Will's blood and DNA would have been present at the site of the wound and on Deputy Hill's clothing. This was not the case. Further testimony stated that a trail of Will's blood was found leading from the crime scene, confirming that Will was bleeding profusely. If he had shot his own left hand less than 8 inches away from Deputy Hill, a significant quantity of Will's blood should have been found on Deputy Hill's clothing, especially if Will had stood over Deputy Hill as he lay on the ground and shot him repeatedly. Only one small drop of Will's blood was found on the tip of Deputy Hill's boot. No other blood was present. Also, at close range, Will would have been unable to avoid getting blood splatter from Deputy Hill on himself and all over his own clothing. Bloodstain tests were conducted on both Deputy Hill's and Will's clothing. A senior forensic expert testified at trial. The officer's clothing, his uniform shirt, his shirt and pants, they came back having the officer's blood on them. He also testified, the clothes Mr. Will was wearing, the jacket he had on, the purple pants that he had on, his shoes all came back as having his blood on them, except his socks. I didn't test them. All came back with blood being consistent with him, his own blood on his own clothing. It was his blood and no one else's, not the deputy's. Forensic pathologist Dr. Jesse Adams' testimony does not support the prosecution's theory that Will shot Deputy Hill from the ground and then fired additional shots when Deputy Hill was on the ground. At trial, he stated the following with regard to one of Deputy Hill's gunshot wounds. This would be consistent with the shooter being to the side of the deputy, or the deputy's head being turned away from the shooter. It would be consistent with both those scenarios. It would be consistent if they were approximately the same size and in a standing position. He added, it would be possible that if the defendant and victim were standing face to face, being handcuffed, someone could approach from the left and shoot. That would be consistent with the entry and exit wounds. Someone could have been hiding in a bush and approached from the left side. This testimony supports Will's version of events and throws into doubt the prosecutor's version, which supposes the first shots were fired while Will was on the ground, the remainder of the shots being fired as Deputy Hill lay on the ground. The strongest facet for the defense was allegations that Rosario boasted to inmates that he was the killer. 4 inmates came forward and stated that when they were housed together with Rosario at the Harris County Jail, he had confessed to them that he had murdered Deputy Hill. He also provided details about the crime that were not publicly known or available. They also stated that Will had always maintained that he was innocent. 3 of these 4 inmates were intimidated into not testifying at trial on Will's behalf, only later providing affidavits. Here is the testimony of the one inmate who did testify in the trial. Harris County Jail inmate Victor Coronado was the centerpiece of the defense's case. While incarcerated, Rosario allegedly told Coronado that they were stripping a car trying to get the rims, stereo system out of it, and a unit pulled up, and that he had no choice but to shoot the cop. It was just instinct, and he ran. He eluded police one time by slipping through them, and when he got closer to home, that's when he was arrested. Rosario reportedly said that his father was a police officer, and it was really nothing anybody could do to him. The prosecution did not present any direct evidence that Coronado had manufactured this story, but nevertheless strongly questioned his credibility. Rob Will was found guilty. There's a lot of legal jargon through the appeals process that I don't quite understand, so I will attempt to explain this to the best of my knowledge. On March 26, 2007, Will filed a federal petition for habeas corpus relief, where he raised 3 grounds for relief. 1. Actual innocence of capital murder. 3 inmates, Rene Gonzalez, Richard Lucio, and Antonio Reyes, have provided affidavits stating that Rosario allegedly said that he, not Will, shot Deputy Hill. 2. Ineffective assistance of counsel. Trial counsel provided constitutionally deficient representation by not securing and presenting testimony from the 3 inmates who had provided affidavits in this case. 3. Coercive and intimidating trial atmosphere. The conspicuous presence of numerous uniformed police officers as trial spectators violated Will's constitutional rights. Will expressed concerns on several occasions regarding the amount of uniformed police officers that were present at his trial on a daily basis. At one point, the judge ordered the doors of the court to be locked because of the overwhelming number of police officers present. This presence in court is known by police officers as the wall of blue, a tactic often used to influence and/or intimidate the juries of defendants accused of murdering a police officer. In the December 2001 Houston Star, a newspaper for local law enforcement personnel, the following notice was on the front page. The trial of Robert Gene Will II, who was charged with capital murder of a police officer, the murder of one of our brothers, begins January 7, 2002, in the 185th District. This is a reminder for as many uniformed deputies that can be there. Attend. The defense objected to this wall of blue, but the judge overruled their concerns, saying the officers had the right to be present. It must be questioned whether having that many uniformed officers standing arm in arm against Will had a prejudicial effect on the sitting jurors. When these facts were presented to the Court of Criminal Appeals, it was noted that they found no evidence that jurors' sympathies were susceptible to being swayed by the police presence, such as it would, for instance, if the jurors had close ties to law enforcement. Meaning, had the jurors had close ties to law enforcement, they would have in fact been susceptible to being swayed by the police presence in the court on a daily basis. The voir dire transcript provided the following information. One juror had friends who were police officers and a brother who was a state trooper. Another juror had a friend who was a police officer who had actually been involved with this very case, the murder of Deputy Hill. This juror also spoke to this officer who was testifying during the trial outside the courtroom. And a juror stated that a good friend of her husband's was with the Houston Police Department. 3 jurors did indeed have close ties to law enforcement. This would have made them already biased in favor of the police even without the addition of a large police presence in the courtroom, which surely could have only added to that bias. Will's petition was denied. And for more than a decade, the case has bounced back and forth between state and federal appeals courts, generating a complex paper trail. And over time, new evidence emerged. jailhouse snitches alleging Rosario had confessed finally agreed to come forward. Jail records about a suspected gang hit Rosario ordered on Will inexplicably appeared in the prosecution's files, and previously undisclosed evidence that could have called a witness into question surfaced according to a 2018 article in the Houston Chronicle. New evidence reveals that after Rosario was booked at the Harris County Jail, he attempted to have the only witness to his crime, Rob Will, killed. Jail records indicate that Rosario was placed into administrative separation in the Harris County Jail after Deputy Hill's murder because he solicited an inmate and a prison gang to make a hit on Rob Will. The discovery of this document led to this recent sworn affidavit of the inmate. Despite having access to these records, the prosecution failed to turn these over to the defense, a clear Brady violation. The new evidence demonstrates that Rosario attempted to have Rob Will killed because he feared Rob would expose him as the shooter in Deputy Hill's murder. In his sworn affidavit, the inmate also reports that Rosario confessed to shooting Deputy Hill and told him he planned to blame Rob. This confession is similar to at least 2 other confessions he made to other inmates. A Harris County jail officer also reported that Rosario had bragged to her about his involvement 3 days after the murder. Because of all of this, it has become more than just a case of freeing an innocent man. It is highlighting what is wrong with the court system when it comes to the death penalty. The death penalty is supposed to be reserved for the worst of the worst cases, but nobody meant that that should be the worst of the worst judicial process, stated U.S. District Judge Keith P. Ellison, who has advanced Rob Will's appeal because of his own inability to do more in a case that experts say highlights systemic issues within the death penalty appeals process. Apparently, under a 1996 law known as the Anti-Terrorism and Effective Death Penalty Act, it added limitations in appeals from prisoners, which means that federal judges are forced to go along with previous state court findings, even if they don't agree with them. Eric M. Friedman, a university law professor, said the case highlights the need for changes in the law. The idea that it would be important to reconsider, rethink, and recalibrate to serve the very appropriate underlying goals of the statute is well illustrated by this particular case, he said. The purpose of the statute is to provide a federal level of supervision of basic rights, like the right not to be convicted and executed if you're an innocent person. That was in 2018. And according to Robert Dunham, executive director of the Death Penalty Information Center, should the Fifth Circuit rule against him, Will's next and final move would be to try and get his case heard before the U.S. Supreme Court. And he might have a chance there. His case is one where the procedural irregularities are so extreme, says Dunham, that if the Supreme Court allows it to stand, it is basically saying that states are free to make death penalty reviews a charade. That is what's at stake with this case. So for now, all Will can do is wait, as he has been doing for the past 18 years since his conviction. But he has made sure to make his time productive. In his early years on death row, Will was more troublesome for the guards when he founded a group called DRIVE, Death Row Intercommunalist Vanguard Engagement, with fellow death row inmates Kenneth Foster, Gabriel Gonzalez, and Reginald Blanton to protest the conditions under which they had to live: tiny cells, crappy food, sleep deprivation, solitary confinement, as well as the upcoming executions of a couple of their friends. In 2005, in what he calls a peaceful protest based on the teachings of Gandhi, he swiped the handcuffs while they were being taken off him in his cell, jammed the door shut, barricaded himself behind his mattress, and waited for the extraction team to come with its tear gas, which it did. But since then, conditions have gotten a little better, and so the activism has slowed down. Now Will spends his time reading and studying. He also paints and writes long letters and blog posts for his Free Rob Will website. He has also earned a yoga instructor certification and a paralegal degree. He has previously had art exhibitions in Germany in 2012 and in England in the year 2017. His most recent exhibitions have been at the Blue Gallery NYC and the Trinity School NYC in 2019. Kathy and her family went on to file a $10 million lawsuit against Will, citing pain and suffering, and loss of companionship and support, while also attempting to stop Will from having access to his prisoner account, which he uses to buy commissary goods and incidentals. The effort was ultimately not successful. She then began helping the surviving spouses of other murdered police officers, earned a position next to then Texas Governor Rick Perry at a 2008 pro-law enforcement bill signing, and got a job as the office manager of the Harris County Deputies Union. According to a 2016 story in the Houston Chronicle, she and her 2 daughters also received hundreds of thousands of dollars in charity. The piece went on to say, on Thursday she was arrested on embezzlement charges, accused of quietly changing her payroll checks over the course of 20 months to overpay herself by $108,000. She took a plea and got probation. As we close, I would like to read Barrett Hill's widow's impact statement. The punishment administered to you is just and fair, according to our law. You did not give my husband the option of life, and so we do not give you that option either. But she may have just said those words to an innocent man. If you enjoyed this video, please hit the like and subscribe button below. If you want to inquire about a commission, you can email Russell at russellstewart.art@gmail.com. You can watch Russell livestream his art on Twitch. And if you want to hear more true crime stories, you can subscribe to my podcast, Crimes of a Decade, a Texas true crime podcast. Now that we are done, make sure to wash the brush. Just beat the devil out of it.